Now, Mr. Bloom, the Britney Spears story alleges a kind of financial abuse as well. In her case, it was abuse of a conservatorship, which has now actually ended. So she just recently released a statement saying that one of the best parts for her of ending the conservatorship was that she is now able to have money in her wallet and she can drive to a store and buy a candle. And that, to me, strikes me as such a small and simple thing. Would a situation like what happened to Britney Spears be possible in Canada?
So we actually do a much better job, at least in Ontario. The legislation is province-specific that governs guardianships and powers of attorney.
And a guardianship would be the Canadian equivalent of a conservatorship.
Correct. In fact, we got rid of conservatorships where you'd have a committee of people take control over assets back in the early 90s. We have the Substitute Decisions Act. And in that context, you'd have a guardian for property and a guardian for personal care that has specific powers surrounding personal care, like diet, hygiene, shelter, medical decisions. And so in Canada, I think we do, or in Ontario specifically, we have a presumption of capacity that's assiduously protected by the courts. Courts look at guardianships like a version of a police power, because once you're declared incapable of managing your property, you're not able to make decisions over your assets. And so if you don't have a power of attorney, imagine the courts appointing someone to make the most basic lifestyle decisions. Some of the most intimate decisions you could make are being delegated to a third party. So the courts take a very, very hard and skeptical look at that because they're trying to protect the autonomy of the individual. And we have a great deal of case law from our judiciary designed to promote autonomy and to prevent what had happened to Ms. Spears, which was horrible.
So capacity is one of those things which isn't really black or white. You know, Ms. Spears obviously had a mental health crisis in 2007. An elderly parent can have good days and bad days. If someone has come out of a mental health crisis and their capacity has improved, is there a way for them to end a power of attorney that is simple? Is there a way for them to end a guardianship? Or is it really a high threshold to overcome that and get out of that situation?
So you're presumed capable of law. Anyone can revoke a power of attorney for property by ripping it up, destroying it, and communicating to anyone who's been relying on that power of attorney that it's no longer in existence. We're presumed capable under Section 2 of the Substitute Decisions Act. And when you have a guardian appointed over you, the ward always has the ability to go back to court and say, I'm capable, this needs to stop. And they have access to their own medical records. One of the very frustrating things in the Spears case was that she didn't have access to her own medical records. Even if you're incapable, you're supposed to, the idea is to foster the autonomy of the incapable individual under the Substitute Decisions Act. So you're trying to actually help them become autonomous. Whereas, so you wouldn't have a situation like in California where the incapable person can't even get access to their own medical records. Here, we're trying to promote their autonomy. We have a great decision of Justice Quinn out of St. Catharines, or former Justice Quinn, he's now retired, called Conscious State, where a husband he's separated from his wife and he has her declared incapable of her assets as he's suing her in the matrimonial litigation. If you could imagine a worse scenario, you have a spouse separating adverse to his wife and then brings a guardianship application over her, has her declared incapable in the Consent and Capacity Board, and Justice Quinn sets aside the decision and says this is like a police power. You can no longer make healthcare decisions, nutrition decisions. Someone can decide where you live. We have to protect our liberties assiduously, and our courts have done a phenomenal job in interpreting the statute to ensure that if people are capable, that they get these guardianships terminated. Capacity is time-specific and matter-specific. You're 100% correct in stating it's not lights off and lights on. It's way more nuanced than that. And that's why it's important not to have a system which tries to take away the rights of the individual. And so I can tell you as an estate and trust litigator, we've had some phenomenal jurisprudence from our courts that has served to protect the rights of the individual and to prevent frivolous capacity assessments. A capacity assessment's a very scary thing in our area of law, because if you're assessed as incapable of managing your property, it can trigger a statutory guardianship if there's no power of attorney potentially. And then you have the public guardian and trustee, a government entity, being the statutory guardian of last instance, where there are no other family members. And you don't want that. You don't want the government controlling your assets.
This
or
is
making
really
decisions.
frightening stuff, and it's huge powers, and I can see how a guardianship and power of attorney can be abused. REA, thank you so much for joining us today.
Absolutely. Thank you, Christine.